Good afternoon, this is Sean Golding with Golding & Golding, here to discuss the delinquent FBAR submission procedures. This is a pretty straightforward presentation, it shouldn't take too long. When someone has unreported foreign accounts or other items that need to go on tax return, life insurance, pension plan, and they don't know they have to file it, generally when they do realize if they had met the threshold requirements in prior years, they have to go back and file past FBARs. Now, when FBAR is the only issue and there's no unreported income, there are some alternatives to some of the more common programs you may have heard: the traditional voluntary disclosure program, the streamlined foreign offshore procedures, streamlined domestic offshore procedures. It's called delinquency procedures. It's called delinquent FBAR submission procedures if it's just the FBAR, or delinquent international information return submission procedures if there's other international forms as well. We'll discuss that in a moment. When there is no change in income, then there's really no need to change the tax return absent possible Schedule B issues. It avoids fines and penalties. So when someone qualifies for the delinquent FBAR submission procedures, even though technically it's not a program, technically there is no certification form, the IRS has essentially said that they won't penalize you. So when you qualify for these procedures, it's something to think about. There are some clients who still prefer to do the streamlined domestic or streamlined foreign. Streamlined foreign, you get to do the program, sign the certification letter, there's no penalty. Streamlined domestic, you receive an acknowledgement. When the person has to go back and submit delinquent FBARs, what will happen is it's only done electronically. And so when you go online and do it, and you put other, you flip down to other, a box opens up on the page which has a certain amount of characters. It is important to make sure that your reasonable cause statement within that character limit is sufficient to include enough facts and circumstances, along with any law, regulations, etc., that puts the IRS through the FinCEN submission on notice that you're submitting these delinquent FBARs in accordance with delinquent FBAR submission procedures. Now, when a person has unreported FBARs, oftentimes there's other international information returns that should have been filed as well. 8938, 8621 for PFIC issues, 3520A for foreign trusts, 8938 FATCA, 8865 partnerships. It doesn't mean that there's any unreported income. It's important that the taxpayer knows about these other forms they may have to file, because once they file these forms, the delinquent FBAR, if the IRS was to audit them, because you can still be audited, and they notice that, hey, well, it's a mutual fund, why wasn't the PFIC filed, or it's a foreign trust, why wasn't the 3520A, or other issues related to it, it could lead to fines and penalties for those other unreported forms. So it's important to do your research, speak with some experienced practitioners, and get a feel for whether there's any other unreported forms that need to be filed. The main takeaway from this is if you qualify for the delinquent FBAR submission procedures, you have no unreported income, just make sure that the reasonable cause statement is sufficient, enough legal and factual background to put the IRS on sufficient notice that the person was non-willful, no unreported income, met the requirements of reasonable cause, and are submitting to the delinquent FBAR submission procedures. My name is Sean Golding with Golding & Golding. You can get lots of free information on our main website, goldinglawyers.com. Enjoy the rest of your day. Thank you for your time.